You have to start.
I have to start, right? Okay. Okay. Good morning, my dear President
Yes.
Ezri. Um, Let me start off by introducing maybe ourselves.
Yeah.
My name is Arthur Wang, and I've been in practice since '91. Seems so long ago. Feel like a dinosaur already.
Yeah.
And I think I started um, risk management in its early stage in, I think, near year 2000, when the then president, Mr. Raguna, brought me into what is known as the PII, Professional Indemnity Insurance Committee. Those days, I didn't know what it was. I joined, and slowly, I then realized it's such an important committee. It protects the livelihood of lawyers because we make mistakes, right? Now, then we developed it to something else. It was, I think, some 5 years ago, right, Sarah? Then we started to prevent all these mishaps. So efforts were then put in to do and started risk management. There we are today. I'm still struggling and trying to learn how best to help our fellow professions to prevent and lessen claims against ourselves. Now, President, um, I don't know you well enough, but I am informed by a little bird that you started practice in '94,
Yeah.
and you would probably share with us, actually, in your early days, you already had client account problem experience.
Yeah. A very bad experience.
So, President, please.
So I started practice I called to the bar in '94. I opened up my own firm as a sole proprietor in 1996. So I started in 1st August. So it's only 4 months lah for the financial year. So August, September, October, November, December, 5 months. So at the end of the year, I submitted for my accountant's report, and they say that I've done everything wrong, and they can't issue me the accountant's report unless I rectify things. I said, what is so wrong? It's about debit and credit, isn't it? So if money comes in, we record. Money goes out, then there's a PV, etc. But then it seems that it's more complicated than that, because I do not know why. And that resulted kata for me to appoint accounts clerk in the firm, because before that I do not have, because it's only me and one clerk. So then only I realized that this is not a playful thing. And at that moment of time in 1996, 1994, we do not have anybody comes and tell us or teach us regarding client's account. It was in later years that it was being put as a subject even in the universities, but then it's like an awareness rather than teaching what client's account is. So that is where I was at that point of time. It's quite difficult, and then it's quite troubling, because we depends on the CJ annual and practicing cert, and without the client's accounts, the accountant's report, we can't apply for our license to practice. That is troubling at that moment of time.
That's why I think, President, the client's account campaign is such an important thing to start with. Unlike you or some local universities that teaches a little bit of accounts, for those who were educated in UK or overseas, this accounting thing was never taught to us, not even in our bar uh, exams. We got GP papers, we got procedure, we got criminal, nothing about accounts. So when I first started my firm, the first thing that I did was, luckily I think I wasn't too stupid. I ran to an accountant and say, look, what do I do? And that's why I think starting out from practice, when you start with a law firm, a seasoned, experienced law firm with the setup and procedures in place, is very important. Many new, younger lawyers nowadays, they set up maybe straight after chambering or 1-2 years. They don't know what the procedures are. And that's why this campaign is important. And that's why we can see the trend nowadays that the claim that we have against lawyers more and more are to do with mismanagement, I call it, mismanagement of clients' account and money. And that has a direct impact into the trust, the integrity of the lawyers, President. Now, can I invite you, President, to talk about some of the experience, apart from yourself, in terms of mismanagement of clients' account?
Yeah, I found there are several ways of the client's account being managed, and most of the time it's not intentional, and sometimes that is because of the lack of knowledge of how the client's account is being operated. So the basic is that client's account only can be opened with the bank. That is also something that is being discussed and also is troubling for some legal firms, because like when we talk about banks, being that banks are registered with Bank Negara and recognized as a bank. So it's either a commercial bank or Islamic bank. There are banks that is not recognized in that sense. Like if I'm not mistaken, it's Agro Bank. You can't open up a client's account in the Agro Bank because they do not have checks, etc. Because that is the requirement under the Act.
Yeah, so members must know this. Even I don't know this. That's how informative this podcast is.
So that is one part of it. Number two is that what money that you can bank into that account. It's not all monies. There must be specific monies that only can be banked into the account. That is specified in the solicitor's account rules, which says that monies to be paid into the client's account is only trust money, such money belonging to the solicitor as may be necessary for the purpose of opening or maintaining the account, money to replace any sums which may be by mistake or accident have been drawn from the account in contravention of sub-rule 2 of Rule 8, and also a check or draft received by solicitor which under Rule 5 he is entitled to split, but which he does not split. So that is the only money. So the problem, one of the stories that I can tell is regarding when you have multiple accounts. Money goes into A client's account, but then when you withdraw it through the B client's account. So that is a problem. So then you have to justify to the satisfaction of the accountants in order for them to see that you have not misappropriate. It's just about you taking it out from a different account, but then the balance must be there. So that is one of the things that resulted to a few firms having problems in getting their accountant's report. So that is one of it lah.
I think another important part of the client's account is the stakeholding part. Many lawyers are not aware that there should be a stakeholding agreement.
Yeah.
And it is in many occasions a tripartite position.
Yeah.
It's not a scenario whereby if a client gives you the money and say it's stakeholding for another customer, for example, and when the client, and this is a real story which I won't share the names, but then when the client says, look, I'm done with this, I don't want to continue with this stakeholding, and instructs the lawyer to release the money back to him.
Yeah.
Now, some of the lawyers will think because it's instructed by a client, money comes in, And when the instruction comes in to say, look, I now want to withdraw it, you perform the instruction.
Yeah.
That would be very wrong. Because in a stakeholding agreement scenario, and every stakeholding position is the same,
Yeah.
where it is for a beneficiary. So the beneficiary must agree to the release of the stakeholding. And we actually have a couple of claims that relates to that.
That is true, because it's very confusing if you do not have the stakeholders terms before you allow the money to come in. So there are a few cases regarding that, which is also being the complaint is being filed by to the DB. The thing is that because when everything is smooth, everything is good, then no one cares about all this nitty-gritty of the agreements, the terms, etc. But then when there are problems arises between the parties, then the lawyers will be the mangsa lah, of which everything goes back to the lawyer. So there are instances of which the lawyer doesn't know where the money or how the money, who the money should be paid for to. So, and then when we ask the lawyers why this thing happens, in actual fact, they do not have a clear terms of the stakeholder trust money. So, and because of that, they do not know whom to pay. So, and because of that, the money is stuck with them. And then that is one of the scenario that I got to share.
So in terms of clients' accounts, some of the things that we must be aware of, ladies and gentlemen, is that it must be reviewed periodically. The client's account that we cannot say that we are too busy and we don't look at our client's account. The client's account must be reviewed periodically. It must be audited. And if you take out client's account money from your account, it's best that you have a double checking scenario, and checks signed by at least two partners would be a much better idea. Right now, there are various safeguards, templates that is actually prepared by the risk management team already, the committee. Do come into, like I said just now, there's a QR code for this. Click into the QR code and you get a lot of information and hopefully some templates that would be helpful to you. That is the whole purpose of having the campaign. Now, moving forward, President, is there any other part in the legal profession solicitors account rules that you'd like to highlight to the members?
Yeah. One of it is regarding the keeping the money. When the money comes in, if there is a certain period of time that the money will be with you, then you have to consider the ruling saying that the money must be placed in a fixed deposit. Well, I can't remember the thing. It's around 3 months, 5 months, 4 months, 4 months and more of 5,000 ringgit. So if it's when the money comes in, then you ask the client, how long will the money be in the account? So if the client says, this one will be there around 6 months because you need to complete a few condition precedents, and then after that, then only the money can be released. So when you have that, meaning that it's more than 4 months, it's more than 5,000, then the money must be placed inside the fixed deposit account. This is one of the main thing that we found that lawyers are not complying. So if you place it in the fixed deposit account, then it's safe because it's not inside your client's account, so it will not be mixed with whatever daily transactions that you are doing. So this is something that lawyers must remember and must comply with. For the time being, the accountants, I feel that the accountants doesn't look at it as it is. So they still just close one eye and then just still issue out the accountant's report.
That's very good from you, President, because I know you don't do convincing. You do litigation, and yet you can tell us all this. And I see from the crowd there are quite a few senior practitioners. And we know, especially some of the litigators, when the clients pay the money into the account, we always make a decision that the money can be used or may be used in less than 4 months, and therefore the money is not put into FD.
Yeah.
And there's a trick to that. Some of them actually gather the money, but put into the FD account and consider the interest their own.
Ah.
So what do you say to that?
Because last time we are allowed to do that, and then suddenly the bar council becomes more alert and stop
Maybe we
us,
shouldn't be so alert to tell the auditors.
stop us from earning from the this one. Also meaning that all monies or whatever profits that you made in the fixed deposit, you must pay it out to the client. But then there are certain things that you can charge the clients with, but then you can't take all the interest the profits from that. It's not like last time when we started practice in 94, 96. These rules are not there, so we can just take out the profits. So it will be our own income.
But we pay tax.
Yeah lah. When if we declare.
We always declare. We always declare. At least for record's sake. President, I'd like to move on a little. The other aspect of client's account are scenarios whereby the lawyers are actually innocent victim.
Yeah.
But nonetheless, I think it's important in our efforts to cultivate more trust and making our profession even more noble. Is the fact that we need to alert our practitioners, our members, in scenarios that they walk into. For example, when you join a new firm, not as an employee, that's the benefit of being an employee. Some of them, they all just want to be bosses. But when you're joining a firm and being a partner, what would be your advice in terms of joining partnerships or taking over sole proprietorship? What are the things that you would advise the members to look into, especially in the accounts department?
I still believe when you are being admitted as a partner, meaning that is a new firm, because in our partnership act it says that if a partner is being admitted, meaning that you are starting it fresh. So meaning that whatever that is the liability and whatever things that happens before that, so is the liability of that the present the previous partners, not the present one. But then in our practice, that doesn't reflect it clearly. But then I think that is the position. So if you are joining a new legal firm as a partner or whatever, then the date that you separate that your liability that come into place must be there. You must know about that, etc. My concern is more about the sole proprietors, because we have a matter, and I always tell people regarding this case, is that a lady who runs the firm as a sole proprietor have around, I think, a few staffs, and she has one trusted staffs who do all the accounts, transaction, etc., PB receipts. So the lady give birth. So when she gave birth, she stayed at home, and the clerks will come to the home, to the house, and give the PB and receipts for her to sign. And then there is complication from the birth. So because of that, she needs more time at home and keep signing the PB and receipts. And then suddenly she got a call from a client, from few clients, asking what happens to their money. Then only she start looking at all the accounts, going into the office, etc. And then she got to know that, the money has been drawn out.
Siphoned out.
Drawn out because she signed the check. So that is one of the case that I think that it should be a case study for us to look into how a sole proprietor, when there are medical conditions or certain things happens, what will happen to them? Because the client's account, you can't get anybody else to sign. It must be a solicitor. But then in that certain situations, how do you manage it? Of which we never address that. So they also do not know. Another thing, if you are in coma or you have suffered a stroke, what will happen if you are a sole proprietor? So that part of things, we need to address, and if there is any advice, we need to give it to our members, especially because it's around 80% of our firms that is in Malaysia is sole proprietor.
That's so true, President. Because I think the first thing that comes to our mind when we have sole proprietorship is we don't get a chance to go to holidays. Right?
Yeah.
When we go on holiday, who goes to court for us? Who signs the check?
Yeah.
But this is so important because when we go forward and we meet with problems, the only advice I can get, and I suppose we can give, is to contact the risk management committee
Yeah.
and the staff as to what you can do.
Yeah.
Like I said, in our initiatives and our templates, we have various things that will be very helpful. But I think we missed this out. And the sole prop, like you correctly say, President, is the majority of the practitioners. So we really need to look into that.
Yeah.
And the committee will definitely look into that. So that's why I think the podcast is good in the sense that it brings up issues, and we would love to hear from members as to what else you want to listen to.
Yeah.
And what are your feedbacks, and tell us what are the topics. And at the same time, sometimes it's not just topics or that you want podcast on. It can be a very simple issue that you have, and we will keep it private and confidential.
Yeah.
I'm sorry, staff, you all will have to do even more work, but I think it's for the betterment of the bar.
Yeah.
Now, the other thing that I noticed from what you say, President, is that, and this is not only for sole prop, maybe the smaller firms, in that we have to almost struggle to survive.
Yeah.
Legal fees are not going up, cost of living is going up.
Yes.
So we are struggling to make ends meet, fees, so on. Especially the smaller firms, the sole prop or 2-3 partners, they have to run out to get clients, to do the work,
Yeah.
collect money,
Yeah.
get our PCs done,
Yeah.
insurance all done.
Yeah.
Where to find time for accounts? And yet, much of the problems can be resolved if we spend time and look at the anomalies. If we look at the inconsistencies when we reconcile our bank account.
Bank accounts.
Of course, how you run the accounting procedures, who signs the checks. Sometimes the partners will say, oh, it's okay, I'll do the business, you run the firm, you run the accounts, I don't want to see.
Yeah.
That's one of the biggest mistake
Yes.
of partnerships, where you overtrust your partner. Yes. I don't think it's a bad thing, but in terms of procedure, it's something that can be improved. And I understand, President, from your legal practice, you have more than one branch.
Yeah. For now.
You have more than one branch. I believe you have KL, Johor, Penang.
Penang, yeah. Thank you for promoting us.
But I think the important thing is this: you maintain one account.
Yes.
Now, I will invite you to talk about that. But I suppose most of the people or lawyers, and this is quite rampant now, what I call franchise law firms, where they get one name and then they start to branch out to various parts of the country. And every partner runs that branch as though it's his own. Now, he wants that brand name maybe for panelship, right? Or he likes to be one of many in a group. and they have individual accounts.
Yeah.
Each branch, this is from the PII experience, each branch run as their own. Every branch is their own kingdom.
Yeah.
And these are one of the biggest problem that we have,
Yeah.
because left hand don't know what the right hand talks about
Yes.
and is doing. And President, do tell us how you run those accounts.
Oh, for us, after looking into a few scenarios that is going on, because we did have one problem with engaging with a firm. So our client asked us to sue the firm. So we tried to get the insurance in, but then the problem with the insurance, since the one of the partner who we are alleging misappropriate this fund is not in practice anymore, because she simply doesn't say she doesn't want to renew her practicing certificate. So because of that, but then she got another partner who is somewhere else. So the insurance said it's about you taking over the whole thing. The partner should take over the whole thing and then put the name in, buy the insurance back, then only we can continue with the suit. But then that doesn't happen because the partner was worried. So she just simply resigned and she went for an in-house, as an in-house counsel, etc. So in that scenario, we have problems getting back the money. So if there is separate accounts for separate branches, we feel that is not it's not viable for us because we can't have a control. So that's why we decided to have only one account for all branches. So it's run by our finance department. But then that is possible because we are of this size. But then if you are sole proprietor or partnership of which only one partner is sitting in one office in Penang, for example, and the other one in KL, so that is not possible for you to do that because that is very costly. So that is the dilemma that all this kind of partnership that we'll be having. So I keep highlighting this partnership of convenience shouldn't happen shouldn't be coming into our profession. But then this is something that is being forced on us because as you said, Dato', because we need to survive. So the bank keep insisting for us to have partnerships. I do not know why, but then they keep insisting for us to have partnership. That is why this kind of partnership happens. But then at the end of the day, the bank do recognize that every branches has its own liability. The bank do that because for us, when we deal with banks, we tell so what is the problem of us having a branch in Penang and also in KL? Why can't we be in the same panel? They said cannot. Or KL has different thing and Penang have different criteria. Of which it doesn't make sense because we are in one account. That the bank cannot comprehend. So in that sense, they still believe that every branches is different. So why do you need to put that condition of partnership? So there is pros and cons. But then this concerns about our insurance. Because if something happens to her or him, what will happen to the branch? Whether the banks can still sue for negligence, etc. I think that is what the bank is worried about, and we never address these scenarios in our discussions.
So the members who listen to this podcast, I think your response is most welcome. And I think it's important so that we actually know what is the real scenario down in practice, and that the council, the bar council, and the committee will be able to, do this even better, even more practical. Of course, President, the client's account is the heart of trust and confidence in a lawyer. and we were just talking about client's account today, but the client's account actually goes on in many areas. I would like to also share one of the experience that I personally have personal knowledge about, where I think it was, if I remember correctly, 4 or 5 partner firm. So this firm, the main administrative partner deals with the account. The rest of the partners would run various aspects, scope of work, convincing, corporate, litigation, or whatnot. Now, when the money comes in, obviously into the client's account, what they do, and actually this is in real life happens a lot, especially to maybe the smaller firms where money is an issue. You've got overheads and whatnot. So they started off by taking client's account out and spent it, right? Paying salaries and whatnot. But at the back of their mind, they're thinking, hey, don't worry, especially for litigation, right? It's money client paid me that I will work in the future. I mean, litigation may go on for 1, 2, 3 years, right? So money put in, don't worry, I spend today, but I carry on working, I'm still around. As they grew bigger, business better, they were still doing the same thing because it's a habit. So the partners will take the money out and put in their own FD account. So no need to headache about which interest goes to which client.
Okay.
And one day, one of the administrative partner actually went to Thailand on a diving trip and met with an accident. And the long and the short of it is this: the money that is in the FD goes to the estate. Goes to the estate. The children say, nothing doing, this is my money. And the rest of the partners, actually, 2 of them became bankrupt because it was sued by the clients. So this I'm trying to say is that the partners in each and every firm must look into your accounts. Not only the running, but you must look into accounts where your money is. You know, don't just overly trust your partners.
On that note, Dato', that's why it's very important for you to have a partnership agreement, or at least an arrangement agreement between partners, how things would matter and how things should go on when, especially when this kind of incidents happens. So what are the things that should be given to the estate and what are not the estate's properties or assets, etc. So all these things must be spelled out, of which I found that lawyers don't do agreements. They do agreements for others, maybe because they can charge. For themselves, they
Because
can't
cannot charge.
Yeah, so because of that, nobody does that. So it's more on oral agreement between them. So that is very high risk.
I think our time is good already,
Yes.
President. Thank you very much for sharing with us, and I hope it's been helpful to the rest of the lawyers and population of especially the young practitioners. I hope that this podcast will ignite your thinking and look into the importance of keeping good accounts, especially the client's account. With that,
So we end with a song.
The only song that I know is Nagaraku, and I will
everybody has to
make
stand up.
everybody run away. Okay,
Okay.
President, thank you very much.
Thank you for inviting me.